May it please your lordship. Lordship, I beg to mention item number 44 of the daily list. The matter may be adjourned for the day, any date after vacation. Lordship. Item number 40, review it.
Consider the present of the prayer made by one constituted. Review petitioner, the member stands it down today. This doctor, as we some way we should have.
Deeply aware.
My lord, I beg to mention that item number 3, my lord. My alleged lawyer is suffering from illness, my lord. This will be taken next week.
This is 2021 matter.
My
We have to
lord.
wait.
My lord,
We are not adjourning without looking at the records.
the alleged lawyer is ill, my lord.
Whatever is the good reason, but these are 2019, 2021 matters. We are not adjourning. I think item number 1 to 7, we are not adjourning.
No, no, okay.
May I please your lordships, my lord, I beg to mention a reputation criminal for listing, my lord, tomorrow.
Deputy Chief. Oh, sir, Deputy Chief.
Next resolution, Lordship, item 22, Lordship. Lordship, after petition any date, Lordship. Today some difficulty, Lordship.
This is 2017 matter. We have to wait. These old matters, without looking at the record, we are not adjourning. We have to wait till the prayer when the matter is called.
Okay.
Lordship, I beg to mention item number 2. Lordship, due to some medical emergency on senior
Who is 2019? No, we are not adjourning item 1 to 7.
May I please, your lordship? No, item number 31. May I allow to pray for its updation?
31. We'll see.
Well. Obliged.
Your Lordship, we please, Your Lordship, I beg to mention an item for listing, Your Lordship.
Mistake.
Also, Your Lordship, I beg to mention items 11 and 13 of the daily list, Your Lordship. Your Lordship, senior counsel is not keeping well. So I pray that the matter be adjourned for other date, Your Lordship.
11 and 13.
11 and 13, Your Lordship.
This doctor is saying. So,
Obliged, Your Lordship.
Supplementary item 46 for withdrawal.
on instructions, Mr. J. Islam, then counsel for the petition. Speak to withdraw this petition. Here is allowed, understands, discuss from the floor. Mr. P. Sharma, Mr. P. Sharma, and additional senior government deputy is present.
For motion, item 1.
Ms. Gauhati, we are bidding it for hearing and the admission stage will consider this.
Yes, Lordship.
Because this come for motion after 2020 for the first time. None appears on call for the petitioner. However, also appeared for the respondents. Pursuant to order passed earlier, the records of the trial is received. The result of the same. Appears that the records need the examination. Returnable on few days after the as all the respondents are represented, no steps are required to be taken. This the matter in the admission column on
31 July.
Verma. Ms. Verma,
Yes, Lordship.
just see page 21. I think you have to ask these tribunal officers to be trained again. They have no idea about the documents which they are dealing with. What I will tell you. Page 21, you have it.
21, Lordship. Yes, Lordship.
In page 21, you will find that exhibit A is written in bold. You got it? Please read that. That it is also noticed that OK have also failed to prove the contents of Jamabandi from the records of the Chikha book by which the certified copy of Jamabandi has been issued. They don't even know how the
I think, Lordship, we are, Lordship, which district is it? Bahaton, Mesa?
whatever thing you have a copy.
No, I have, but I have a Gwalpara district and my trade 21 is,
They are giving the records to you.
my 21 is a voter district.
They are giving the
Oh, this is actually.
This is item 1. This is still item 1.
Oh,
You just look at it.
I have item
No, it's
1.
okay, just look at that.
21.
Yes, exhibit A, just 2 lines before that, 1 line before that.
Yes, Lordship.
It is also noticed that these have also.
During the course of evidence.
No, just
After that.
just A, exhibit A, just above it. Exhibit A is in bold.
Lordship, I am not very clear, Lordship. Yes,
As exhibit A,
yes, yes, Lordship.
line above. Just above that, it is.
OP
This
has
is,
failed
this is
to,
also noticed.
the Lordship is reading, OP has failed to substantiate the existence.
No, page 21. Page 21.
I'm on 21.
Exhibit A is written in bold,
Yes, Lordship.
in the middle, just above that.
It is also noticed that OP have also failed to prove the contents of the Jamabandi. Exhibit A from the records of the Cheetah book by which the certified copy of the Jamabandi Exhibit A has been.
Now, the traveler does not even know how to read the land revenue document.
Yes.
You see, a Jamabandi is never checked with a Chitta record.
Chitta records.
Chitta goes to a Jamabandi.
Yes.
And once he gets a certified copy of a Jamabandi, then you don't confirm it with a Chitta. Chitta is only a draft.
Yes, Lord.
So they have absolutely no idea what they are dealing with.
Yes, Lord. Lordship, we can take up this when during the orientation program.
So, but you have to do it. This is high time. You have to say.
Mr. Payang is already talking with the government on that, Lordship.
But you see the flaw. And that's why it is, this is rejected. It's a certified copy.
Yes, Lordship.
The certified copy rejection itself calls for a demand back. We don't have to submit to any other company. And there is nothing in this, there's no merit in the matter otherwise, just for this flaw.
Only for one. Lordship can record it, and the next, even we'll make a mark it when the matter is next listed, so we remember it, Lordship.
For motion, item 2.
Yes, I don't know.
Lordship finally allow a short wait.
What is inclined to issue? What is the motion? Return of a non-citizen. No steps are required to be taken. All the respondents are represented. This is the matter in the evolution going on. 31 July.
Item 3 for motion.
করেছি বহুত কত জরুরি নতুন দিব লাগবে তো আপনি তো আরো 10 বছর পরে আছে আছে কি হওয়ার পুরানো বেলা পুরানো বেলা কি হয় যেগুলো কিছু
আমার লেখা আছে আমি পড়া যায়
Yes, Mr. Rajabunga.
Hello.
Yes, what do you have to say?
My lord, I had not. My lord,
What is your submission?
oh, my lord, I I don't know, my lord, my engagement is suffering from illness.
Lordship, a copy of the petition may be served to me, Lordship.
I think it's first time, another way and place for example.
That is what we're saying. After that, I go my
No steps is required to be taken, you say correct. Just get there. Step of the recognition, the south of the line. I'm looking for the matters in place. This should be addition column on 31/7. Yeah, you should notice 31/7.
Item 4.
Here is received, I think.
Yes, Mr. Sir. Yes.
Here has been received. It may be fixed for admission here.
it appears that when the DMARC, it's a devoto case, when the DMARC was inserted, the case of the petitioner is that the surname was changed from Laskar to Borgia. Surname in the voters list was changed from Laskar to Borgia. And therefore, there was a DMARC. Then he raised objections. After several years, this objection was ultimately attended. Please come to page 56. The additional speech says no DMARC case. Here it is Laskar. Correct. Now come to next page 57. Here the matter is referred to the Deputy Commissioner. Next page is the Deputy Commissioner's letter. The last paragraph. No other inscription of Borgia surname instead of Laskar sufficed name of so and so. And therefore, instead of Laskar, Borgia is inscribed, which is also a matter of clerical mistake. And then it says that the documents which speak in favor of the nationality are so and so. And therefore, there's a request for removal of the DMARC.
Yes.
Next page, 59.
Copy of the authenticated.
No DMARC against Abul Hussain Borgia. This is coming here. This is you'll have to examine on the next date. You make your submissions.
Lordship, Election Commission will ascertain this.
Whatever, yes.
ECI will do.
Sir, you give one copy to Starling. Okay. That will be prepared of that. It said there's a clerical mistake in the change of name.
Cannot be certain, but.
When we sometime I'll upload the instruction document. If that is the case, then his D may be removed also. The direction is sent because
Here in the meantime, the Foreigners Tribunal has already decided the matter.
it's
But with regard to this, if that stand is accepted, then matter has to be remanded back. Perhaps. I've not examined the opinion vis-a-vis this. I've not examined.
the very first paragraph itself says it is on the basis of the LGO report.
Yes. So once it is there, I stop there and I just take it. If the record is here, I will examine it. Which respect and not question. Same question to all. contents of I'm sure 14, 17. Request the reference communication for the different instructions. Permitted to send a download copy of the follow. This is the emission from 51.
Obliged. Item 5.
Maybe red judicator.
My lord.
Taking up the red judicator.
Yes, sir.
The earlier opinion,
My lord, case 22, my lord.
22.
Yes.
And the other opinion,
My lord, opinion dated 19/8/2014, my lord.
14.
Yes, my lord, 2014. There my lord, the impugn notice at case 27, my lord.
What are you trying to show from page 14? Why did you refer to page 14?
It's 14. It's 71 important list, my lord.
Who is this?
My lord, Jamir Ali is the my lord father, the petitioner.
Mr. Hawk, since the Abdul Qudus case is very clear, we are remanding the matter back. The tribunal will first examine the issue of res judicata and then proceed.
My lord.
That exercise will be have to done by the tribunal.
Yes.
So you take a plea and then they will decide the issue of the previous opinion.
Yes, sir.
Then take up the matter on merit.
My lord.
Whether he's one and the same person.
On the
Lordship.
Yes, madam.
Lordship has passed a very recent judgment on this, and the judicata.
I think,
Lordship. Good to dear son. We were just going through it the other day, Lordship. It helped us a lot.
480 on PCS,
I have a weak memory, I forget.
20,000.
Definitely. That was a contest, same plea, Lordship.
also maintain this in my record.
Now we're trying to refer to new judgments, Lordship, because there's so many of them and new issues are being taken up in most of the matters now.
As top learned counsel for the petitioner, and so and so for the respondents. In brief, the case of the petitioner is that on the basis of a reference made by the Superintendent of Police within bracket border, bracket close, Sonitpur, Tejpur. The the a case being FT case number 84 of 2014 arising out of SP case number 104 of 2014 was registered before the Foreigners Tribunal within bracket second bracket close Tejpur. Sonitpur, Tejpur. On receipt of the notice, the petitioner, namely Mohammed MD Umar 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 Ali, entered appearance in the matter and filed his written statement. And in his evidence, the petitioner had exhibited the Prohibitions of 1965, where the name of his grandfather, namely Rabin Rabel Ali, was enlisted. So 1965, take it next week. Thereafter, on the basis of the other exhibited documents, being the voters list of 1993 within bracket exhibit B and Bampura certificate within bracket exhibit C. Learned member from a foreigners tribunal second on faithful. Rendered an opinion that the petitioner is not found to be a foreigner. Thereafter, the petitioner is in receipt, next part. Thereafter, the petitioner is receiving receipt of another notice from the Foreigners Tribunal 6th, Sonitpur, Tejpur, No, Sonit at Sutia, SOOTEA. It will be Vishwanath. Sonit 76, Vishwanath. Yeah, that's how. Now, what is this? The district is Vishwanath, but the tribal is in Tezpur. Is it so?
And then probably
Page 27. So no, make it 56, Tezpur Sutia.
manager.
Lordship, it is from Foreigners Tribunal, FT6, Tezpur, Sutia.
Very SP borders. The border hospital is reference number PZP within bracket P bracket close public 0
nine.
9 public 3527 dated 30/12/2009. Being FT case number FT within bracket C FTC within bracket C bracket close 550/2018. So this is not 686 FTC within bracket 6 550/2018. Fixing the date of appearance on 2/11/2021. Accordingly, the aggrieved petitioner has filed this recognition in the Article 226 of the Constitution of India. Instruct the Learned Counsel for the petitioner by invoking the principles of res judicata, which has been laid down by the Supreme Court of India in the case of Abdul Kutlu versus Union of India, within bracket 2019, bracket 6/6/604. Case for quashing of the subsequent proceedings and the notice dated 5/10/2021. Next. The Learned Planning Council for the FT and Border Matters. Would takes note of the fact that the issue regarding res judicata was taken up by this court on an earlier occasion in the case of Jamiluddin, JAMI, RUDDIN, it's the Union of India and others, WPC 4801 of 2025, decided on 51/10/2025. In this decision, this court had accepted the well-settled position of principles of res judicata applies in the proceedings before the orders tribunals and took note, further note of the fact that the decision in the case of Abdul Kudus within bracket Sufa has been followed in the case of Tara Bhanu T-A-R-A-E-A-N-U Begum. Twenty 25 within bracket 4 GLT within bracket C bracket 36 and Swapan Datta. This is Union of India and others. Civil Appeal number 6799 of 2025, decided by the Supreme Court of India on 14/5/2025. And REGIA, REGIA, PHATUN, alias REGIA, REZIA, Hatun, within bracket Sutra, not Sutra, you just say that civil appeal number within bracket not provided in copy supplied bracket 4 public 2025. Second bracket arising out of SLP within bracket criminal bracket 4 number 12481 public 2023, decided by Supreme Court of India on 11/2/2025. Second bracket closed. And Sital Mandal versus Union of India and others. Within bracket 2022. Within bracket 3, bracket GLT 95. There are three court was of the view that in order to apply the principles of the judicature, it is the first and foremost requirement of the orders of the United Orders Tribunal to determine whether the proceeding in the previous proceedings is the same person who is arraigned with the proceeding in the subsequent proceedings. Accordingly, the court took a view that unless the petitioner files his written statement and produces documents on which he intends to rely on, only thereafter the United Orders Tribunals will be able to arrive at a satisfaction that both the proceedings are one and same. At the same time, the state respondents also advised also produce evidence to the United Tribunal to show that the proceedings in both the cases are different. However, if the tribunal arrives at a satisfaction that the proceeding in both cases are same, then the United Orders Tribunal shall be bound to apply the principles of res judicata in light of the law well settled on the point. This court took a further view that this court is exercising secretarial jurisdiction and therefore has a very limited jurisdiction, which is limited to only determine as to whether the orders passed by the tribunals are perverse and illegal or is otherwise sustainable. And in that regard, the court had relied on the decision of the Supreme Court of India in the case of Central Council for Research in Ayurvedic Sciences versus the Captain Das, as well as paragraph 20 to 23 of the case of Hari Vishnu, HARI-VISHIU, KMETH versus Ahmad ASMED, Ishaq ISHAQUE, AIR 1955, SC 233. Accordingly, this court has taken a view that in the absence of any determination by the valid tribunal as to whether or not both the proceedings are the same person, if this court ventures to examine the documents of the petition, then this court will be exercising housing jurisdiction, not vested on this court while deciding a rate petition under secular jurisdiction. Therefore, following the decision taken in the case of Jamiluddin Mola within the Super, even in the present case in hand, is for the learned foreigners tribunal. Given an opportunity to the petition, final written statement and produce all the documents on which he brings to rely. And the state respondents, by so advice, may also produce evidence for the learned traveler to show that the proceeding in FT case number 84 of 2014 were decided on 19/8/2014 by the Ordinance Tribunal, second zone faithful. And the proceeding in FT within bracket 6, FTC within bracket 6, bracket 550 of 2018, pending before the Foreigners Tribunal 6, exposed to the different persons. Accordingly, the learned member from a Foreigners Tribunal 6, exposed to the on a plea of res judicata being taken by the petitioner from a shall first determine whether the proceedings in both the cases are same, and then learned tribunal can be bound to apply the principles of res judicata in light of the well-settled law on the point. Next, I just further clarified that if it is found that the present petitioner is the same person, in respect of whom within the 19/8/2014 was passed in FT case number 84 of 2014, the present proceedings in respect of FTC with the bracket 6, 550 of 2018. Shall be dropped. Next one. according to this resistance disposed of on terms of, on the terms as indicated above. There should be no orders with construction.
Right.
This and petitioner will be represented by the, appear before the said learned tribunal on how much time?
Mhm. Mhm. Any day in the month of July, my lord.
Besides, the date will fix it on that day. You can go 6th of July.
6th of July. They can, they can.
6th of July is open
Yes,
there.
they can.
6th of July 2026. Therefore, this is a separate of the wait for the access of the state. In the meantime, the registry shall send back the records back to the consent tribunal.
I am obliged.
Sir, how? I think we'll extend it by 1 week. The records may not reach.
16th, Lordship.
6, make it 13.
Okay.
Because take some time to record.
Okay.
Item 6 for motion.
Obliged.
Yeah, please, Your Lordship. Lordship, here in this petition, my lord, jurisdictional aspect has been, my lord, in dispute, my lord. And on the last order by order dated 7/12/2021, this honorable court was placed to direct the respondents to take instructions whether the jurisdictional aspect, which FT would be the appropriate FT, my lord. Initially, my lord, this proceeding was started before the Foreigners Tribunal Techpur, Foreigners Tribunal First Techpur, my lord. Thereafter, by order dated 18/5/2018, page 23, the learned tribunal has passed an order that since the petitioner is a resident of Misamari, so the appropriate tribunal would be Foreigners Tribunal 8, Chalamora. And subsequently, again, on 19/10/2021, this order was, my lord, changed. It was cancelled, and it was directed that no, the appropriate jurisdiction is FT 1 Techpur. And initially, my lord, there was an ex parte order against that ex parte order. Challenge was made before this Honorable High Court, and by order dated 18/12/2017, this Honorable Court was pleased to direct the petitioner to appear before the learned tribunal and to file evidence. That the case has to be started from the stage of evidence. And thereafter, this proceeding, my lord, is now stayed at the stage of evidence.
Once this court gave you direction to appear there,
My lord.
18/12/2017 order has to be complied with.
Yes, she appeared, my lord. She appeared. Kind of find,
Why should jurisdiction would come now?
my lord, kind of find at page 23, my lord. This jurisdictional issue was summato taken or raised by the Honorable learned tribunal, my lord. NHL 6, madam. Page 23. Except 4, madam. Sorry. Proceeding is absent due to her appearing in NRC hearing. Counsel for the proceeding has taken step. It is seen from the record that the reference is not under jurisdiction of Tezpur police station. The address of the suspect is mentioned as well as Dekia Pelwa Kachari under police station Misamari. Therefore, this case be transferred to the FT8 Tezpur, Telamara.
Oh, no, we have all, this matter is all well decided long back,
My lord.
that the record would have no jurisdiction under section 24 to transfer the records from one tribunal to another. This court in its wisdom had sent the matter back to the same tribunal.
Yes, my lord.
Proceeding has to go back, otherwise we'll have to file,
No,
unless this order.
She appeared before the,
12. Now it has been sent back,
yes.
then
She appeared before the, my lord, as per directed by this honorable court, before the FT1 Tezpur.
it's okay, but now you see this page 24 order has been passed.
Yes, my lord.
So notice again,
Yes.
this,
Yes, by this order, that order was, my lord, set aside, or it is reversed, that jurisdiction would remain, it is the existing tribunal, my lord, that is FT1. So thereafter,
correct,
my lord. Thereafter, my lord, since earlier it was directed that,
can't challenge this order of 1910,
my lord, 1910.
that can't be challenged.
My lord, it hasn't challenged because, my lord, it is rightly or wrongly petitioner on the strength of order dated 18/5/2018, he filed a petition that saying that she is a resident of Misamari and she is ailing lady.
This court had, this wisdom has sent the matter to the same tribunal.
My lord,
We won't have jurisdiction to take a different view. It would amount to a review of the earlier order.
my lord.
We cannot.
But in this petition, she has taken this plea that the distance is in comparison with the Telamara, this is big distance, as well as having financial condition hardships. And
Yes. Ms. Verma,
Yes, Lordship.
she's a resident of Misamari. There is a tribunal at Misamari.
Telamara it is.
I think by the last order, we were in office to get instructions, Lordship, will fix it up next week. The instructions must be in the office, Lordship, we missed out this matter somewhere. We get the instructions, Lordship, exactly where it is.
At present, the school is one of person. Proceeding is somebody, or Misamari, it is FD person, it is another person.
But no reference for this.
References to the one of this one.
Inquiry protection.
Enter Misamari proceeding. They get the door out. Here noticeably, while reversing that order dated 18/5/2018, the learned tribunal on 16/3/2021 has opined that since the case has been sent back from the Honorable High Court to this tribunal.
Baba, you just only have to find out. Please come to page 13.
I don't have the petition.
Give a photocopy to her.
Yes, you do.
Come to page 13. At page 13 is the earlier opinion, which is ex parte. Now please see paragraph 1. This is a reference made by Superintendent of Police Sonpur Tejpur as per clause 2(1) of the so-and-so, whether opposite parties are foreigner or not. Now the address given here and the above is resident of so-and-so is Misamari.
Misamari.
Now perhaps at that point of time, Misamari tribunal was not there.
Yes, Lordship.
Now this, the ex parte order was passed by Tejpur first. So this court, now please come to page 19. He filed an application for vacating. This case was registered, rejected.
Yes, Lordship.
Against this, the litigation was filed, page 19, 168.
20.
Now, here the court interfered and sent back the matter, giving an opportunity to contest the matter back to Tejpur first.
Yes, Professor.
In the meantime, Misamari has perhaps started functioning. So, page 23, the tribunal says it will not have jurisdiction sent to Misamari. Thelamara, sorry, sent to Thelamara. Now, having sent that, then passed the order, later on the tribunal realized that the High Court had sent it to him. Now comes page 24 order.
Yes, Lordship.
The earlier order is recalled. Since the High Court is sending, we can't send it back. So it is recalled. Now, the petitioner now files an application again at Tejpur, saying that now since Misamari is there, please send us back. Page 28 is the order. High Court has sent it, we can't, and therefore rejected. Again, he has come to High Court. Since Misamari is there,
So, I think you should have filed a review for the High Court order
it's okay, but
because there's a delay, Lordship, from 21.
that's why we are taking it up.
Yes, Lordship. Lordship may modify that previous order and
Set back.
yes, send it back, Lordship. No need to file a review in this with only, Lordship, and modify that order.
We will not modify that, but having noticed that
Jurisdiction has changed.
in the meantime, Ramara is there.
Yes.
Now we are not touching that order.
Yes, Lordship. Because there's a very long delay, Lordship. This matter is of 2012. The
Expert was there.
We saw it and thought that it should
and
be,
more delay is causing more anguish, Lordship.
in fact, if you need, you can speak to people at 2 o'clock also we can pass an order. They're not in a hurry. If the Misamari is functioning,
Lordship, Mr. Pang is on legs, Lordship. Will come.
it's okay. You can just take instruction whether Misamari, the Thelamara is functioning.
Yes.
Then we can send it back.
Yes, Lordship.
At 2 o'clock.
Misamari or Thelamara, Lordship?
Thelamara.
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 Village is Misamari
Yes.
And jurisdiction would be Thelamara. We can give her a copy to it, easier for her to.
Yes, actually. It was two other things. The fixed question and factor and everything.
Item 7.
Right, what should be if you order is page 23 lottery? I will simply order lottery, the tribunal lottery rejected all the documents lottery. And finally lordship, declared the petitioner as foreigner lordship. Lordship, the petitioner exhibited 12 documents lordship. And for linking lordship, the petitioner exhibit 9 lordship, that is the Jamanmandi lordship, where she has inherited the land of her father lordship. That document was also lordship rejected with the tribunal lordship. Since 1951, lordship, she has exhibited the documents of his father lord. Rahmat Ali lordship. Lordship, exhibit 9 lordship. But Jamamandi lordship. Here lordship, repetition it was not NI lordship, but it the record lordship. Lordship, here lordship, it is the Jamanmandi. The remarks of the Jamanmandi, it is clearly mentioned there lordship. Father was died lordship, child died lordship. Father died lordship in 1991 lordship. What's the it is? Yes. The name was maintained on 2018.
which are created post reference.
The source reference,
But
yeah.
in the documents you will find is given the original sale deed of 65, and then there's a what do you call exhibit 7 is the mutation order, which is of 65. There, serial number 22 or 23, the name of the order is there.
Yes, okay.
Then he has also submitted the original pata.
Okay.
Original pata also contains the name of the father.
Father.
And thereafter the mutation. Mutation may be delayed, but there is a link. They are
For 65.
in the written statement, 34, paragraph 4, discloses 3 brothers and
9 sisters.
sorry, 4 brothers and 9 sisters.
Yes, Lordship.
All these names we have checked up is there in the job.
It is there.
So there is a link. Just examine, we'll take a break and come back.
Lordship is,
The view of the tribunal is not incorrect because we took the same view
yes, Lordship.
that once it is post reference document,
It
they
should
will
not be.
look it very cautiously. But
Yes.
here there are two circumstances which we wanted to show it to you. You see, the owner on different what you call even for collateral reasons may include the petitioner as one of the legal heads, but they will not give the original pata and the original sale deed. Please check the sale deed is original and the pata is drawn but original. No, not this.
Okay.
This is a sale deed.
But that will same the
Next page, yes, that's the sale deed.
this one,
After that.
Lordship. Is the original, this one, 65 word. We have to support number 65, we will not get your seat. Sixty-four. Link to asset. Father went over the future loans for me. Father.
That was correct.
Yes.
We don't, then the tribunal need to be same view. Because it's a post reference document. But here the also sale deeds and all are produced. That perhaps
Some link.
you may want to help me, but you will not like to give me the original things.
A well kept document of 64, Lordship.
Certified copy would not have accepted it.
Acceptable.
You want to examine, you can examine, we'll take it up at 2 o'clock or some other day. We can work.
That is good. The after, Lordship.
Take the record maybe. Both sides are represented.
Lordship's record would be in the custody of Mr. Pine, Lordship.
This is J. Pine, I'm standing also for the tea and water matters. There's leave of the court to examine the records and to address the court. So accordingly, the records of the tribunal is handed over to him for perusal and to address the court on the next date of the next paragraph based on 19/6/2026. Mr. Payang, you can just come to page 34 of the written statement. In this written statement, paragraph 4, 5 and 6. Paragraph 4, they disclose the names of the brothers and sisters, page 34.
Yes.
Then paragraph 5, NRC reference is made. Paragraph 6, the land documents of 64, 65, 67.
Yes.
These documents are here.
Let me explain.
Just giving you that reason why what you have to see that. Okay.
Item 8.
This issue, the petitioner. Moreover, as per office note dated 3/6/2026, no affidavit is permitted by order dated 3/9/2025 has been filed. For the end of justice, the matter established on the it's made clear that if the petitioner remains absent on the legislative proceeding, the matter is orders to follow. Based on 22/6/2026. I'll be responding to them.
Item 9.
My lord, did this matter come after vacation, my lord? Because initially, my lord, while dictating the order, there is a correction required to be made, my lord. Accordingly, order was passed with regard to the cost title, respondent number 5 and 6. So, my lord, that has been done, my lord, that has been come to record.
No, that is not done.
My lord, it has filing section, it has not come to record. That is filing, my lord.
No, without the record, how in the filing section you can do it?
Yeah, my lord, let the matter come after vacation, I will do the next one.
Is it presented? As per office note dated 3/6/2026. The amended cost title has not been filed. The pair made by non-profit, the matter stands on the day. This now, give a date after vacation. Date after vacation. Promotion.
31 July.
Item 10.
So the last one for director to file me this amended procedure and file it by tomorrow, lordship. Can you take up the matter on Wednesday next?
Represented, Mr. M. Rana, and also for the petitioner. Contradicts to and the by 18/6/2026. This again. 22/6/2026.
Lordship.
item 10.
Item 12.
May please, your lordship. The opinion is at page 70, annexure 19.
Mr. A.R. Sigdal, I think the council assisted by Mr. S.H. Sigdal, and council for the application. I think it's at page 78. Dated 27/2/2026.
क्लियर जगह थी नजर नहीं
This case number is wrong below. I want to write. This is customer service. By which the petition was declared to be a following postman by 396 in the stream. Notice returnable in 4 weeks. Extra copies will be today's or for the record. Prayer for bail is opposed by the relevant standing counsel to the FT matters. Concerning the petition, and is trying to take bail of this 5,000 to the satisfaction of Superintendent of Police Border. Which place?
My lord, Bozali,
Basadi.
district Bozali, my lord, SPB Bozali. D block.
Item 14.
Part time. Part time. Us, this is more than, this is part time. 43 filing this third time. First time is 62.
Will you say order of reinvestigation,
Lordship, Annexer 20, page 92, Your Lordship.
page?
92, Your Lordship. Since the matter is pending like that only, Lordship.
This is not order of reinvestigation.
Magistrate order.
It's an order for reinvestigation.
Page 92.
Page 91, Your Lordship. I'll come to page 91, Your Lordship.
No, it's not this.
No.
This is not reinvestigation.
Order is about magistrate order. Even the third time you said.
Yes,
Third
Your
time.
Lordship,
Last time.
Lord, Lordship,
That's so available. That's final issue. Huh? No. It's wrong. Just a pending as well.
how many reports? Closure report. Closure report. It's a closure report, page 70.
Every charge sheet has been filed. Order of prison. File is going on. File, we have to have you some.
No. It will ask for the one, but one.
So we will put this one. I have 2%. Just to give it up again. Just to give.
Last quarter, one policy, part of the minister policy.
And it's
Thank you, community.
Publish the investigation. And then report of FRA. Fine. I have this special message. Recent. I have, still going. No. And they have to be. Investigation itself, against the function investigation.
We are having some difficulty in following this regulation. Your, whatever we have understood is that this is was your brother. He died in the, on his death, the case was registered, resulted in FIR. You submitted an RRJ petition, and on the basis of that, a complaint case was registered. Now, in a complaint case, when the orders are passed, normally a magistrate would only pass an order of investigation. But you are using the word re-investigation. We have doubts whether whether a judicial magistrate will have power for re-investigation. High Court can issue a directions, but whether the magistrate can pass an order of re-investigation, we don't know. But we could not find it readily, but there's an order of this court which says that even if the order of re-investigation is passed, it will be treated as further investigation. That order we could not find right now. Now, the fact is that if investigation has been ordered on the basis of a complaint case, the magistrate will be in possession of the matter. Now, the last order which you have annexed here is 6/9/2025.
Yes, no, yes, Lord.
So that's what has happened. So
Nothing, Your Lordship. This is the last order, Your Lordship.
after that, there's no order in the.
No order. That is why on the last occasion we withdrawn the case to search for these orders. This is the last order, Your Lordship. No, nothing, Your Lordship. And the petitioner is like a fatherly figure, Lordship. He is seeking justice, Lordship. We have tried everywhere. And before is that also many affairs were filed, your lordship. We have managed those affairs, your lordship. That is the background. That is why we are troubling your lordship every time. Yeah.
In 6-9 order, the IO stated that the investigation is going on.
Yeah. That was simply, lordship, was simply seeking a direction to transfer this case to some independent agency, your lordship.
I have stated all these one, re-investigation case is still going on. And respondent number 6 minus is vice.
Yes,
Negate party member, respondent number 6.
What is strategy board of investigation? But we said that particular ask for the petitioner and each one for the respondents.
Respondent number 1 to 5. 1 to 1, 2, 3, 4.
3, 4,
4.
5 also.
5 investigator officer, SI 5.
Case of the petitioner is that agreed by the final report submitted by the IO in connection with Corpeta PS case number 989/2022 under section 120 capital B /306 IPC, the petitioner, who is the brother of the deceased, had submitted an objection against the closure report on 18/12/2024. It is projected that pursuant to the said objection, a further investigation was ordered by the sub-divisional judicial magistrate within bracket S bracket close Corpeta. Full stop. The learned counsel for the petitioner, by referring to order dated 6/9/2025, passed by the learned sub-divisional judicial magistrate in the S bracket close Corpeta, in connection with Corpeta PS case number 989/2023, had submitted that as per his instructions, the said last order in the proceedings was passed on 6/9/2025, where the IO had stated that the reinvestigation of the case was going on. Submitted that. Even after about 9 months from no report of further investigation has been filed, and no date has been notified for the proceedings of the said Gauhati PS case number 989 of the. Next part. Accordingly, court is declined to call for the status report of the investigation from the investigating officer of Gauhati PS case number 989 of the 2022. Under section 120, capital D of the 306 IPC. Next, the learned additional senior government advocate has sent the announcement of this order. The officer in charge of Barpeta Police Station,
Barpeta Sodar Police.
Barpeta Sadar Police Station,
Yes, sir.
Whether it is Sadar or simply Barpeta Police Station.
Sadar, yours.
But the final report was submitted by Barpeta Police Station.
Barpeta, yours. Barpeta.
Barpeta,
Yes.
we named him by the Barpeta Sodar. Barpeta Sodar. Barpeta Sodar. And then look at this Barpeta Police. Barpeta Police. Same name. No. Okay. Okay.
because you see, we have a bad habit of cross-checking everything. In the Assam Police portal, there's no Barpeta Sadar Police Station. We are giving you this.
But he making party is a corporate soccer.
That we don't know. I have personally no idea of visiting police stations.
Yes, sir.
Have you made that statement of Barbara Sadar? I'm not personally aware of it. So I'm sending you the state portal. State portal does not have Barbara Sadar. The CGM writes Barbara police station.
What should you, then we allow to amend.
Police station.
Corporate police.
Corporate police.
If you are writing another word, we have to cross check. List of.
Upside,
Send it down.
maybe you said after vacation.
List of.
After vacation.
After the question. July.
20.
20.
Oh, 1300 month after together.
Item 15.
Wait, special lordship.
Yes.
Impugned order lordship is 59 lordship.
59.
Lordship.
Previous order, very pending bill.
Okay, back to the.
And Mr.
M. Mondal.
M. Mandal, then council to the petitioner. This date page 59.
Yeah.
So and so.
Which-
The case number,
Just point.
case reference number so and so. By which the petitioner was declared to be foreign of compared to 19th
Lordship. So,
Notice extra copies included, so after the record, therefore bail is offered. 10 days time to take bail of this white person. To the satisfaction of superintendent of police order. Which place?
Borpeta lordship.
Bombay. List after 4 weeks.
Item 16.
opinion date to कोई भी होने
Impugned order at page 64, your lordship. Contested matter, your lordship. Date of opinion 27/3/2020.
Same order. Next to Sabha, next page. 17 to next page, Roshan. And you.
Golbara. Golbara.
Did you question? Let's have GPT.
Mr. Bless you.
It was date TI maybe. Happy with that, sir. So being order page number 47. Contested person. Yes. MD meeting.
23 to 2024. page 47, passed by so-and-so in case number so-and-so, SP reference number so-and-so, by which the petitioner was declared to be a foreigner for 25 stream. Notice returnable on, please date. 31 July.
31.
Returnable on so-and-so, extra copies will be included for the records. Therefore, bail shall be considered on receipt of the travelers records. In the meantime, if the petitioner, namely so-and-so, is apprehended, he shall not be deported out of the country without order of the court. And the petitioner shall cause collection of certified copy of the order before the superintendent of police order, taking of the notice of the said list of.
Alia business.
Item 18 for motion.
May please, your lordship.
Yes, Mr. Hassan.
Lordship, impugned opinion is page 112.
Page
112.
112.
So,
The FA Hassan, I will consider the petitioner and also for the respondents. Page 112, opinion dated 29/12/2025, passed by so-and-so in case number so-and-so. IMDT reference number so-and-so. It is in the text. They were declaring the petitioner to be a foreigner of 425 in 97 street. Notice returnable in 4 weeks, extra copies within 2 days for the record. Therefore, release opposed. Then this time to take below rupees 5,000 to the satisfaction of SP border.
Borpata.
Supreme of this.
Public.
Item 6. 6 at 2 p.m.
So do the FTE. The FTE one.
Yes, my lord, I have seen, my lord, page 28. There is some order, but
No, you have to see from page 19. You see, there was an ex parte opinion that is at page 30. Yes. Page 30 is an ex parte opinion of 24/5/2016.
yes.
This order was challenged before this court. And this court by order at page
19. 15.
19.
19.
This is ex parte opinion, application was filed to set aside ex parte order. That this case was also dismissed. So then page 19 order of this court, the court remanded the matter back to the same tribunal. Page 21.
Yes.
It was sent back. Now the tribunal on receipt of the record found that the petitioner was a resident of Visamari and therefore Thelamala would be the tribunal. So page 23 is the order. Correct?
Yes.
So 23 sends to Thelamara. After sending on 18/5, it realized that the order was wrong because I could have transferred it to, I could have sent the matter to that.
Test, FT test, once.
Yes, and therefore it recalled its earlier order and started the proceeding again. Now the petitioner has filed a petition that I am a resident of Thelamara. Jurisdiction is Thelamara, therefore please transfer it to Thelamara. Now the tribunal has rejected that. So ordinarily we would not have sent the matter. Because transfer is otherwise impermissible. Our
Yes,
court
yes,
has decided that.
yes, ma'am.
There are two decisions we have got that can't be sent.
Yes.
But
it's
here the
done.
petitioner says that jurisdiction would otherwise be there. Because when this order was passed, page 13, perhaps the Thelamara tribunal was not there. That is why we wanted you to take instructions. Page 13 order was passed, Thelamara was not there. In page 13, you will find the address Thelamara is given there. In town, here district in Mistamari. Police station is in Mistamari. So
Yes.
Mistamari would be Thelamara. Therefore, this is not a case of ordinary transfer.
Yes, my lord, this is if, my lord, the thing is that, my lord, transfer is not allowed. If it is bifurcated, the records were bifurcated during, my lord, due to change of addresses,
Then it can be sent.
and then it is an administrative process, it will automatically be. Let me get instruction, my lord, tomorrow or day after.
Yeah. Then if the banker is coming to speak here about my this law. Thinking
Day after tomorrow. 18, 19.
district orders would have been passed.
Yes, probably.
Because of the High Court order, they are now not doing it.
Yes, my lord.
Correct. So we wanted to refuse that. He says that she's poor. Traveling distance will be too high, too long.
Then in that case, my lord, the order should be reviewed. The order should be reviewed.
We do that. We say that this tribunal has come into existence, later to that,
Yes, then automatically it should go there.
it should go there. So we are not touching the earlier order of this court. We are not
Yes.
passing orders on review.
Okay, that will do, ma'am. I'll get instruction. Okay.
Item 19.
Exactly, Lordship. My lord, page 90 is the opinion, my lord. 19. Opinion is 7/2/2026.
9-0.
90.
Mr. S.A. Ahmed, petitioner. Page 90 is the opinion. 7/2/2026. Bail will be to the satisfaction of
Noga,
Police
ST Noga.
Nagaon. Okay. This after 4 weeks.
Obliged.
Item 20.
Yes, Mr. Lordship.
Yes.
Order at page 47.
47.
Yes, Lordship. Petitioner come lately, Lordship.
Are the regions clear?
Lordship, have a look at page 10, Lordship, 10 para 11.
It's a consistent.
Yes, Lordship.
This does not give you knowledge of 19 and 26 is 7 years. You don't get the benefit of 7 years from this. It doesn't say that you are hospitalized for 4, 5 years, 6 years.
Lordship, after surgery, he is fine, Lordship.
No, but you see, your case is that you were suffering from
Abdominal
disorder
pain and
vomiting.
vomiting.
That would not take you 6, 7 years. You said that you could not come to that time because you were suffering from abdominal pain. That means 2019,
Lordship.
for this you can't be in bed for 7 years.
Does not affect medical certificate of the previous years.
Oh.
2026 you have submitted.
Lordship, notice may be issued. I am not going to pay for protection.
You will not be entitled to even for notice. This is insufficient explanation. Studying, being time, examine. If you came through Siraj Mandal, he's your grandfather.
Yes, Lordship.
1966 and 70 is his notice list. Your father's notice list come in 1997 and 2010. Your name is enrolled in 1997,
97, Lordship.
but marked as D. No,
Yes,
no, no, there's no document annexed to show how you are connected to your father and grandfather. What are the documents you have exhibited?
Lordship.
You exhibited the copy of those voters list of 66, 70, 97, then 2010. Then PAN card, computer certificate, affidavit, land revenue receipt.
But father deposed, Lordship.
There's no document to connect
Father deposed, Lordship.
Abdul Kader.
Yes, Lordship.
Your father did not exhibit any document to connect you.
But he claimed he is the son, Lordship. Proceedings.
There is no evidence.
And voter list 1997.
That is only on oral evidence. Did you read the entire opinion before you filed this writ petition? Did you read the entire opinion?
Yes, Lordship.
You read. But then you missed out entirely what should have been a good ground. See paragraph 5 at page 49. You had a good ground, but you missed it. Therefore, we are compelled to say that you have not read the opinion. Paragraph 5 says that you took 6 months time, 8 months time to examine 2 witnesses. And thereafter you took further time, 8 months time, nothing happened. And on the date when the matter was closed, neither you nor your advocate was present. And therefore, when the order was passed, there was no argument at all from your side. But in your presentation that you were ill, you now admit that you know about the opinion. Therefore, that limitation would start for running from the date when the opinion was passed. They deemed to aware of it. So therefore, the only document which connects you to your father is the PAN card. Exhibit E. Your father's evidence was dealt with by the tribunal in a very appropriate way. Paragraph 15 to 18 is devoted on your father. Father's evidence is his, his evidence displays his credibility. Where is your written statement?
Yes, 17 Lordship.
T.
17. Answer. Lordship.
97 hotels list.
Vernacular at page 31, Lordship.
7.
Yes, Lordship.
No, 97, what is that, page 26?
Yes, that is 35 documents.
Your father and your grandfather were somewhere together in some water here.
No, Lordship. But grandfather name, Lordship, grandfather name is against my father name, Lordship, in 1997.
1997?
Yes, exactly.
Your father is that Khairuddin.
Khairuddin is grandfather, and Abdul Qadir is Abdul Karim is father.
This is your grandfather.
Yes, Lordship. Yes, Lordship, name discrepancy is there. That has been explained in the WA.
You are blocking us wherever we want to read something. The photocopies are done in a manner which makes everything unreadable. And when you try to match your story, everything falls apart. Somewhere you have written here that your father died after 1970. Either written statement or evidence you have given that. Your grandfather died after 1970.
70.
Now, if he died in 1970, how in 1973 he can come and pay land revenue? Pay only one land revenue. 73, neither it is there in 72, neither it is there in 74. That person come and pay land revenue.
Yes, he died after 1970.
After 1970 can be 2006 also.
Lordship.
Or I'm sorry, 26. Made a mistake. Slip of tongue. So we don't know anything. You see, it is so vague that you can't make out the story. Before this, annexure 7 at page 30, we can't read. Then you have given us uncertified copy of the voters list at page 32. We can't read. You see, when you make up a case, then what happens? Come to page 33. Your name is Dilawar Hussain.
Dilwar Singh.
Yes, you are 41 years of age. In 2017, you make a statement here that you have seen your grandfather. That means if 41, if you have seen your grandfather, assuming that he was there when you were born in 1976, your grandfather was alive.
He said he was 10, 12 years of grandfather died.
And you were 10, 12 years when your grandfather died. But he vanishes after 1970 voters list. He's not there with your father. So if he's there in 76 and 12 years, that means his existence is there till 1989. But he suddenly vanishes. So you see, that's why we asked you this question. When he, after 73, how a dead man can give. So then we find out when we read further that he was alive till 1989 according to your own calculations. Doesn't match anyway, it doesn't match. So we'll be dismissing it. We'll pass orders in December.
Okay, at least notice issue.
No. Because the delay is not explained. In 2019, you have the knowledge of 2000, the opinion. Therefore, of course, if Mr. Payang saves you.
Apart from the need for,
Cross-examination, he said, I was 10, 12 years when my grandfather died.
Page 37.
yes. Even He said he do not know about his date of birth, but he has given him a PAN card where date of birth is mentioned in it. That particular
We do not see the PAN card. Which page is that PAN card?
PAN card is not annexed, but it is mentioned in page 34 minute is mentioned. Or 35 para 9 minute. So if PAN card is there, PAN card
It will have a date of birth.
yes. But in his cross, he said we don't know his date of birth is specific. Another aspect that is rightly stated, apart from delay and lapses, whether the first voter list of the projected father is 1997 at the age of 47. From if we see, my lord, if we calculate, he is eligible to cast vote in the year 1971 itself. If he is 47 years in 1997, the projected father. Now the link between the father and the grandfather is not there. That is the point in unmarried man. If he is born, the father was born in his 47 years in 1997. His date of birth will be sometime in 1950. So if he was born in 1950, he became 21 years in 1971. So at that time, the minimum age of voting was 21 years. So he was the projected father was eligible to cast vote in 1971 itself. So from 71 to 1997, there is not a document allowed. And the village is also different. Apart from the father's name, my lord. In 1970, the projected grandfather is Soraji Mondal, and who was my lord, a resident of Posim Deulasi Nonke. But in 1997, the projected grandfather is Soroyuddin. Along with the Abdul Karim name is shown as Soroyuddin, madam. Father's name is shown as Soroyuddin. In the village, there are 3 villages. Posim Dev is there, Kayakosi Kothar, but it is Abdul Karim, son of Soroyuddin, resident about 57. So father's evidence, apart from what they have discussed by the tribunal, can be discarded on this ground itself, madam. Whether his citizenship, the citizenship of parent is also necessary to be proved in this kind of cases now. So father's existence is only from 1997. So even though he becomes about to link himself to his projected father, then also it will not help him out now. He has to link to his projected grandfather, who was there according to him in 1970 voter list, Soiraji Mondal. That link is not there.
Study and the question and it's going for the response. List on due next Monday. 22 it's for delivery orders.
Or motion, item 47.
Yes.
May I please also? My lord, the impugn order is on page number 39, your lordship. The,
Three,
yes, 39,
page number 29.
39, 39. My lord, the 11th portion is, your lordship, 40, page number, paragraph 3, your lordship. This is an expletive order, your lordship, due to unserved notice, your lordship. I could not serve notice, lordship, due to the notice was served on the notice board of the local Gauhati, your lordship. But my local Gauhati still did know any inform about this case and notice, your lordship.
Yes, Mr. Fine.
So, my lord,
Yes, Gauhati.
39, page number. 44.
Page 40.
Yes,
Second
40.
paragraph.
Paragraph 3, man.
No, paragraph 2. Page 40. Second paragraph.
Second paragraph. Oh, second paragraph number. Numbering, there is some mistake in line. Paragraph number is some mistake. The service of notice returned with service report on perusal of the date is founded pursuant to the notice process server accompanied by the hour went to address of mentioned in the notice. After inquiring local village people came to elect a official policeman went to some of the president. The residents could not be find it out. But my lord, still date I have been deciding the same place, lordship. In this regard, the local Gavra, that means the Amnul Gavra, your lordship, has issued an certificate in the name of me, your lordship. The same certificate, your lordship. Okay, comfortable. Okay, comfortable. Oh, you can be comfortable. Have it. Last residence will be.
No, here the process server takes two steps. In this paragraph, first it says that we went to the location.
Yes.
And we get house, no one's there. In the next line, it writes that we could not trace out the last house.
Yeah.
So we send it back. It's come. So this is Islam, then come for the petitioner and so for the respondents. So by filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated, ex parte opinion dated, page 39. 12/10/2023, passed by so-and-so, in case number so-and-so, our case number so-and-so, thereby declaring the petitioner to be a pardon of 425 to 1971 street. Next paragraph. The case projected by the petitioner is that the notice was not served in accordance with law. So therefore, the the court is inclined to quote paragraph 3. Give a bracket and then say that there are two paragraphs numbered as 3. And the first paragraph 3 deals with the service of process. Bracket closed. Page 40. Paragraph 3. Next paragraph. Although the learned standing counsel for the border and FT matters has made its submissions in support of the impugned opinion, but the observations made in paragraph 3 quoted above discloses that the process server accompanied by Gauhati went to the address and came to know that the petitioner had changed her address. And in the same breath, it is also mentioned that the process server, after a diligent search, could not locate the last residence. Therefore, notice was affixed in the notice board of the Gauhati. Next part. The provision of order 3 within bracket 5 within bracket small f of the foreigners within bracket travels bracket close order, 1964 is quoted below. Next part. Accordingly, it is held that the notice was not served of the petitioner in accordance with the provision of order 3 within bracket 5 within bracket small f of the foreigners within bracket travelers bracket close order, 1964. Which vitiates the impugned ex parte opinion dated 12/10/2023. Accordingly, the court is inclined to set aside the ex parte opinion dated 12/10/2023. Past it was page 39. Next paragraph. The matter is remanded back for a fresh opinion by the said learned tribunal by giving an opportunity to the petitioner to file a written statement and evidence and to take such other steps as he may be so advised. He may be so advised. The petitioner, who is duly represented by permanent counsel, is directed to appear before the learned member of Foreigners Tribunal 7th Corpora on on 13/7/2026, and along with the certified copy of this order, also file a written statement of defense. As well as documents on which the intents will rely upon. Next, the learned tribunal shall give sufficient time to the petitioner to read evidence, take such steps as he may be so advised. Next, the learned tribunal shall make an interview to control the proceedings within the time prescribed by section 3 within bracket 14. Order 3 within bracket 14 for the Foreigners Tribunal order 1964. As far as practicable. It is just allowed to the extent is litigate the work by demanding the matter back to the settlement lab for a fresh decision. You know what else to do.
Hello, please.
The pan, you can also communicate so that the traveler knows about this order, yes, to the SP order. Yes. Item number 50 is I have asked to get some instruction. What instruction is being given? Item 20, 28. Great. It will be left over, it comes some other day. Yes. Some favors made for updating a matter.
Item 31.
Yeah, please, Manoj. Well, page 28 is only impugned opinion. No? This is an expert opinion.
No, this has to be set aside. Same thing. Here is the report. We dictate order in the chamber because we have to rise for the single bench. Please check up the orders tomorrow.
Right. Obliged.
Your Mr.
Yeah, Roman.
A. Rahman.
Now it's
Rahman. We pass up in the chamber.
Right. Obliged.
For admission, item 21.
Amit was sitting here. Yeah, Amit. After some time. Item 17 call. Give us work for item 17 call. Actually, item 21.
Item 22.
May I play the question? In this relationship, taken up after vacation any date, Lordship.
The foreigner must
Mr. Pai. Copy of the litigation. Come to page 46 first of the litigation.
Para 43, ma'am.
Page 46.
Yes.
Discussion and results.
The opinion.
46 is the opinion.
Yes. 46, ma'am.
You have seen that 46?
Yes, ma'am.
Now see the records. First, you will find 1966 voters list. After the, yes, somewhere here. There is a photocopy. Yes, before that, yes, this one.
Yes,
Now, this is not a certified copy,
this is not.
but the tribunal writes certified copy. Correct. Now change the next page. These are certified copies.
Yes.
So these are discarded as not proved. No?
Yes.
Correct. Now, so 1970 also is there. These are,
70 is there.
yes, 70 is there, 85 is there, 1997 is there,
Yes.
but the tribunal rights not proved.
Yes.
Correct. Now, 2-3 pages down below, you will find the evidence of the headmaster recorded. He would be DW too, but in the opinion, without discussing anything, it says that the proceeding could prove link certificate exhibit G, school certifying Abdul Malik is the son of so-and-so is proved on record. But you see, whose evidence has been proved is not stated. The headmaster was examined.
Now,
Is
it's reflected in the deposition of head teacher.
So that the teacher was examined is only one line written somewhere that
Yes,
reflected in the deposition of head teacher. Head teacher would be DW1 or something which you intelligibly understood. And this document is not proved. There is no reason assigned why not proved. And his misreading exhibit, the first exhibit, 66, saying it to be a certified copy of voter list. Total non-application of mine.
Yes.
You can discard it, but give us sure reason, not proof. There is not a reason.
Yes, this, there are the discussion in wisdom. Yes. This is the estimate of time.
You see, this 86 voter list is which exhibit? No effort at all.
The certified copy of voter list for 3 years. No, it is no record.
Can come to irrelevant conflict repetition. Please come to page 28. Page 28, you will find paragraph 6. My grandfather's name has been recorded in so-and-so. Exhibit A, Xerox copy of certified copy. They admit it's a Xerox copy.
Yes.
Then B, Xerox copy of certified copy of voter list of 1970. 70 is a certified copy.
Yes.
Now exhibit C, Xerox copy of 85, but it's a certified copy. Correct. But everywhere he gives the
Xerox copy.
exempted entry. What is there? My father's name, my grandfather's name, then he says my father shifted. Exhibit D is a certified copy of voter list of 1997. This is how it is proceeded. But in the opinion, nothing is clear. appears that this was his first case. He does not know how to write limits. And for the traveler also, it was his first case.
Even exhibits where documents were not exhibited. Documents were also not exhibited. There is no exhibit signed.
That's why I said, the advocate's first case and the traveler's first case. Send it back. At times the travel try to guide them.
Yes.
Nobody is interested to learn.
This was in 2017 probably. Yes.
For this particular traveler, we had also earlier also flagged. Anil Sharma. Anil Sharma. He is the presiding officer, page 60, page 45. Orders to be taken. Sending it back. We'll record her name.
Look. I was sorry, Lordship, I was busy another.
Whatever, we give her an opportunity.
Lordship.
Yes, your name?
Mizre Akhtar.
J. Akhtar. You have read something we have sent you? Next time be cautious. Sorry, Akhtar, Lanet, appearing on behalf of Mr. M. Khan Lanet, counsel for the petitioner. Also, counsel for the respondents. You get the name, huh? Next. If you don't get my words, please ask me there. Huh? By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 14/9/2016 passed by the learned member, Foreigners Tribunal 6th, Dhubri at Bilasipara, page 45. In case number so and so, reference number, FT number so and so, TR number so and so, by which the petitioner was declared to be a foreigner of post 25/1971. Next paragraph, while the learned counsel for the petitioner has made her submissions in support of against the impugned opinion, comma, the learned standing counsel for the FT and border matters has made his submissions in support of the impugned opinion. Next paragraph. In view of the nature of order proposed to be passed, comma, the court does not find it necessary to deal with the pleadings and the evidence letting the case exhaustively. Full stop. Next paragraph. It was suffice to mention that the petitioner in his evidence on affidavit had exhibited 6 documents, being the voters list of 1966 within bracket exhibit A EXT full stop A, comma, voters list of 1970 within bracket exhibit B, voters list of 1985 within bracket exhibit C, certified voters list of 1997 within bracket exhibit B, voters list of 2010 within bracket exhibit E, and voters list of 2016 within bracket exhibit F. So also one more, 7 it will be, and school certificate within bracket exhibit G. Full stop. Based on the said evidence, comma, the learned tribunal had given the had given his discussion and reasons in the impugned opinion as follows. Copy from page 46. There's a pencil mark. Huh? Next paragraph. Just send the records back. Next paragraph. It appears that the learned counsel for the petitioner is also at fault in not handling the not handling the matter properly. Though the evidence on affidavit was filed on (18/6/2016), comma, but there's no signature or date at the first page thereof, comma, which is normally the filing page. Moreover, none of the exhibits were brought before the learned member for marking as exhibit under his signature, under the signature of the learned member. So, on a perusal of the record, it appears that The voter list of 1966 is a photocopy. The voters list of 1970 and 1985. Sorry, 1970, 1985 and 1997 are certified copies. Voters list of 2010 and 2016 are photocopies of the electoral roll and the school certificate is a counterfile which contains the mark of exhibit capital G and exhibit 2/1, 2 within bracket 1. So, however, comma, the said school certificate contains the state emblem. The records reveal that the headmaster of the concerned school was also examined as witness. However, the deposition sheet does not refer him to be DW2. Okay. And that his evidence was recorded on 8/7/2016. Appears from the deposition sheet as well as the order sheet of 8/7/2016. The record also contains a photocopy of the identity card of the head teacher, which was marked as exhibit 2 within bracket 1, and duly compared and signed by the learned member of Foreigners Tribunal, 6th Jubilee. So thus, comma, there is a repetitive marking of exhibit 2 within bracket 1 in the school certificate within bracket exhibit G, as well as in the photocopy of the identity card, which is available at page 49 of the PCR. Which from the record reveals that that at page 50 of the TCR is a copy of the school register, which has been seen and signed by the learned member and the relevant entry is seen and marked by the learned member under his signature, and the school admission register, a photocopy of the school admission register was signed as was marked as exhibit EXT 2 within bracket Roman 2. So the TCR also reveals that a notice was sent by the tribunal, learned tribunal, to the election officer, 35 Abhayapuri South, within bracket SC, bracket close LAC, regarding a particular voters list containing entries of names of 3 persons without indicating the year of the voters list. To stop. The said notice is available at page 54 of the TCR. And the election officer, North Salmara, Abhayapuri, by a letter dated 18/7/2016, had verified the names of 3 persons whose names were referred to appear in the voters list of 1966, 1970, and 1985. And the supporting documents, which are available at page 55, 56, and 57 of the PCR, is though photocopy is countersigned by the election officer, not Sarmara Abhayapuri. Here, the court is surprised, next paragraph, the court is surprised to find that though the reply letter dated 18/7/2016 by the election officer from North Sarmara Abhayapuri is available on record at page 53, the order sheet does not reflect the receipt of such records or regarding the and regarding the enclosures thereto. The record of the order sheet also does not reflect issuance of any notice to the election officer to submit any report. Therefore, the impression gathered is to the effect that the proceedings before the proceedings of this case before the learned tribunal was whimsically conducted and by an unreasoned opinion, or the petitioner was declared to be a foreigner. Accordingly, the court has no hesitation to set aside the given opinion dated is page 45, on the ground that it is a totally non-speaking order. Where the, even the evidence, where even the pleadings and the evidence of the petitioner was not referred to. The procedure adopted by the learned tribunal in the present case is effective as none of the exhibits were signed, and there is no record of the receipt of the information sought for by the election officer. Next paragraph. Resultantly, the requisition stands allowed. Next, the matter arising out of FT case number 6/344/2016, page 45. Is remanded back to the said learned tribunal for a fresh opinion after giving opportunity to the petitioner to have the exhibited document marked as exhibits to be countersigned by the learned member of the said foreigners tribunal. Thereupon, and thereafter, on hearing both sides, a fresh opinion shall be rendered by the said learned tribunal in accordance with law. Next, the petitioner was duly represented by his learned counsel, is directed to appear before the same learned tribunal on 17th July. You get sufficient time. 17th July 2027 by producing a certified copy of the order. I wait for further orders to be passed by the said learned tribunal. The registration of the sent back the reports to the learned tribunal. Now with a copy of the order to be made a part of record by the said learned tribunal.
Single bench, item 1 for hearing RSA 102/12.
Just now matter is finished.
Which one?
In Kottavadu I was, so I could not come here.
Oh. Yes.
Please, for your lordship, that is the plate, my lord. That is page 30, paragraph 1, my lord.
Just a moment.
It is admitted for the fact.
Just a moment.
Case 30, memo copy.
Just wait. This one. Yes, you are referring to appellate judgment, page 8, para 9, issue number 5. That was you were referring last.
No, I was referring to paragraph 1 of the plain, my lord.
Paragraph?
Paragraph 1 of plain, my lord. Plain, I don't believe before the time. Because the reference made by my learned colleague, my lord, for the appellate. I was referring, my lord, paragraph 1 of the plain. We start from page 38, 37, my lord. The relevant portion is page 38 of memo provision.
Yes.
Page 38, my lord. I am speaking about 6 lines, my lord. We are on 7th line, my lord. The Patada Ramnath was in possession of 1 bigger relations of land covered by the including other land. This is most relevant, madam. There was another plot of land measuring 2 bigger 1/6 acres covered by Pata number 72 in the names of Giri Chaudhary and Lake Karna Chaudhary. During the settlement operation, the Pata was issued in the names of defendant number 1, Giri Chaudhary, madam, and plaintiff number 1 and 2. In the same Pata plaintiff, in the same Pata, the plaintiffs were in execution position by a settlement and such defendant number 1 was not in possession of the land. This was the case, my lord, set out by the plaintiff before the trial board. Plaintiff was enjoyed Patna, my lord, and this is admitting inter alia that I was having half share over this land. Nowhere is a plaintiff. This is the statement of the plaintiff that the land sold by the defendant number 1 in favor of defendant number 2 belongs to the share of the plaintiff, my lord, in terms of any individual settlement. This is not the case of the plaintiff before the trial board, my lord. Now your lordship can see paragraph 2. In spite of fact stated about defendant number 1, he could neither be in favor of defendant number 2, which was later need number 12, then passing 1 bigger 30 lesser of Pata number 72. My lord, this is the sale of the plaintiff. The Pata number 72 contains land measuring 1 bigger 1/6 lesser in the names of 2 patadas. Defendant number 1 being the one of the patadas, having half share over the sale, he had executed this mind only in respect of his share, not beyond that. And another land of covered by that number 1042 and 1017 and Pata number 72, 75 of Pata number. In the same deed, another 4 leases of land covered by that number 499 of Pata number 27 of Patala from has been donated and plaintiff has no objection to it. So, my lord, whatever land the defendant number 1 had transferred, he did, my lord, in favor of defendant number 2, was only in the respect of his half share. And my lord, exhibit. Exhibit 4, my lord, and exhibit 4. Both are similar document, my lord. Registered deed, dated 20th March 1998, my lord. Exhibit 4 is certified copy of the same deed, my lord. The exhibit 4 is the original copy of deed exhibited by the defendant during the trial before the trial.
Exhibit
Co.
K.
KA Co. This is the only exhibit from the side of the defendant before the trial.
Exhibit K is
Certified copy, the original copy of deed.
original copy of the
Deed. And exhibit 4 is the certified copy of the same deed. Relied upon by the appellant.
yes.
Now, my option after the order, let's say, you know, the exhibit 4, it is exhibit 4, my lord. This is appointed here. As is scheduled, my lord. That defendant number 1 of the suit, my lord, he transferred the land of his share on it. Specifically mentioned, more on top in the exhibit. For the exhibit called, my lord. This was also not the case of the plaintiff before the trial court, my lord, or if the report is on court. Defendant number 1 was not taking his share of the, so that is what I read. My lord, after receipt of the sound from the trial court, my lord, defendant number 1 had filed the list before the trial court, my lord. Let me kindly see that page 41 of memo 40, my lord.
21.
41.
41.
And relevant portion is 42, my lord, paragraph 6. Defendant number 2, hearing, my lord, had admitted that he was having share which has been transferred in favor of defendant number 2 by way of gifting. Paragraph 6, my lord, I am reading. That the suit land is the property of authorized defendant number 1 as fall in there by amicable settlement.
You are reading where?
Paragraph 6, my lord, page 42 of memo 40, my lord.
Paragraph 6.
6, my lord. Page 42, my lord.
Yes.
That the suit land is the property of authorized defendant number 1 as fall in his share by amicable settlement between the brothers of defendant number 1 who possessed the land since long time back. So defendant number 1 was the rightful owner and possessor in respect of the suit land. The defendant number 1 being the rightful owner had the capacity to make the transfer of the land. And this is the fact was known to the plaintiff as the suit land fall in the share of defendant number 1. The family members of defendant number 1 assured, although their names are found in the revenue report, they would never claim suit land. And in course of time, they would make arrangement for cancellation of their name from the revenue record in course of time. After independent number 1 was in the belief and being rightful owner executed guilty number so in favor of defendant number 2. This fact of transfer was also known to the plaintiff and other related members of their family. So, my lord, regarding execution of the guilty man of Hendra himself, donor himself admits before the trial court, yes, I have intimated that he did, because I was having half share in that disputed target for the land. That much he has come about that. So, my lord, now, any question, my lord, regarding validity of deed is not having any relevance.
Yes.
Even, my lord, the witness number 1 of this deed, my lord, he was DW2, my lord, Pawan Chandra Sharma. He was one of the witnesses of this deed. He was examined at DW2 before the trial. In his evidence, my lord, he has supported the execution and registration of deed in favor of defendant number 2 by defendant number 1.
Yes.
My lord, this was the case projected by the plaintiff before the trial court, that they are in possession of the Sudan and Patel land, my lord, without denying my half share over the same land. So, my lord, this is my respective position. Possession of a co-owner, my lord, over a joint property, my lord, becomes a constructive possession of all the co-owners, my lord. By virtue of his possession, my lord, he cannot claim that he is the absolute owner of this property. He is in possession, in constructive possession of other co-owners.
No, but that argument would not, would be misplaced here, because you don't, both of you,
My lord.
you don't claim the land to be ownership.
My lord.
Ownership you're not accepting.
My lord, plaintiff says, my lord, whatever was issued in the name of defendant number 1 and plaintiff, my lord. Paragraph
There would be joint owners.
Yes, my lord, joint owners.
Joint owner, possession by one cannot be possession by the other.
Yes, my lord. But my lord, my ownership is not in dispute, my lord.
Hmm?
My ownership is not in dispute, my lord. Furthermore, my lord, from exhibit 1 and 2, these are the Jamabandis of both the two Dagin Fakta.
How do you get this land, by purchase or by inheritance?
By inheritance, yes, my lord. By inheritance. Both my lord, plaintiff has also inherited, defendant number 1 has also inherited. This is the same of the plaintiff himself, my lord, themselves, my lord, in paragraph 1 itself. There were big plot of land, 37 acres, 2 cut and 3 lessons. John left behind by their predecessor, succeeded by the plaintiff and defendant, my lord. So, my lord, from peculiar exhibit 1 and 2, my lord, it shows, my lord, the same contains a big area of land, my lord, in the lands of all the plaintiffs and defendant, my lord. Because defendant number 2 being Donny of the exhibit in question, my lord, he is also co-partner. He is also having share in the Sudan partner. By right of, by,
If they're the members of the same family deriving title through inheritance,
my lord.
because here we have seen that the litigation amongst you is going on since 1998.
1998, my lord.
Yes. Can you have a mediation sitting here? No, they're not possible.
We have not, this can be referred by law. This can be referred by law.
No, if you have to ask the parties if they are ready to accept it. Because if we have lot of land that can be exchanged and it can be settled otherwise.
My lord, then I have to take instruction from my client. An attempt can be made, but this is my oral submission before your lordship. I can agree and make my client agree to seek for mediation, my lord, because this is a family property containing huge area of land. And all of them are very separate share, they are
One can be accommodated here and there, and then adjustments can be made.
Yes, my lord. Yes, ma'am.
Can you speak to Mr. B.D. Deka?
I called him, my lord, just before standing, my lord. He is not picking my phone. I have agreed to bring him, ma'am.
You make your submissions, and in the meantime, in the evening, you can talk to him. Tomorrow morning, you can tell the court master.
My lord, both will come up before morning, my lord, and make it. So, my lord, this is the case.
No, in the morning, we don't have a division bench, so a single bench. So you'll have to tell the court master.
My lord.
If you are agreed, just tell the court master.
My lord, we should try to apply this on court itself, my lord. Why this court will exist?
No, but this matter cannot be taken up in division bench. We can't.
No, my lord. Why this court will seek singly, my lord? When this court will seek singly, my lord, then make it.
No, tell them in the morning.
Communicate our version to the court master.
How to the court master in the morning?
My lord.
And we'll come to know about it.
My lord.
Yes.
So, my lord, this is the case was projected by the plaintiff before the trial court, my lord. And my lord, after completion of trial, the trial court was pleased to pass the judgment, my lord. Let me kindly see, my lord, page 26, my lord, in respect of issue number 5. This is also placed by my learned colleague, my lord, on last occasion. Page 26, my lord, this is the judgment of the learned trial court and findings in respect of deciding issue number 5. Page 26, my lord.
Just a minute. Twenty-six.
26, my lord, memo copy. This was, my lord, in respect of decision in issue number 5. My lord, issue number 5 was page 25, my lord, whether the registered indeed number 22, that is 22, of Atachar Puchi Servicer Office is illegal in a particular law. This was the issue number 5, my lord. And while deciding this issue, my lord, the trial court has recorded its finding only on the ground there. The donor was not having possession over the land. So give it is illegal. Donor was not having possession over the land. So give it is illegal.
Yes.
In page 28, my lord, last paragraph in can see, my lord, page 28. Page 28, my lord, General to Tarun Sharma, my lord, from bottom, my lord. General to Tarun Sharma, the whole, in his examination, it seems that he was attesting witness of the registered Gimli and he knows the order offer and acceptance of the property of the Gimli. The executed Gimli was fit and found to execute the Gimli at the time of execution of the Gimli. Exhibit Cover 1 is his signature. In cross-exam, it stated that it was written by the petition writer and stated by Gil Chaudhary. I think it was executed in the house of Gil Chaudhary. At the time, Minister, petition writer Gil Chaudhary, Pavitra, and he were present. After execution, they after they went away. It is submitted by the this statement. It is submitted by the advocate for the plaintiff. The deed was executed in the place on 13/3/98. This is not having any proof.
before the trial court, my lord, because the deed contains signature of two witnesses. One of whom had appeared before the trial court, deposed as DW2. As the execution is not proved and the deed was registered on so-and-so, attestation of GDD is not proved. Further, it is submitted that the gifted property is an undivided property. Gift on undivided property is invalid is in law. Further, it is submitted that the delivery of possession is essential in gift and gift deed of defendant number 1 is invalid as the possession of the land was not delivered to the defendant number 2 by defendant number 1. And it is suspect Leonard County Advocate for the plaintiff has submitted the case law AI 1971 Himachal Pradesh 5. Further, Leonard Advocate for the plaintiff submitted that gift deed was not attested by at least 2 witnesses. So the gift deed executed by defendant number 1 is not valid. And in this respect, he submitted the case of AI 1975 Patna 440. From cross-examination of DW1, it is seen that the case is running for land of DAC number 1017. This is incorrect, my lord. Case is not running only for land of DAC number 1017. The true property of 3 dams. So from the above, we can see that from the above fact, it is seen that the land of DAC number 1017 is in possession of the plaintiff. From exhibit code, it is seen that nothing was written in exhibit code regarding delivery of possession of the land. Further, from cross-examination of DW2, it is seen that the deed was executed at the house of Mr. Green, and after execution of the deed, they took tea and thereafter they went away. So DW2 stated nothing regarding delivery of possession of the gifted property. Further, though PW1 and 2 stated in their evidence that gift deed was executed also to by deed demonstration, but from exhibit 4 and 4, it stated that gift deed number 1 was executed on 20th March 1980. From cross-examination of DW2, we see that the gift deed was not attested by 2 witnesses, as DW2 clearly stated in its cross-examination at the time of execution of the gift deed, he along with some research, petition item, defendant number 1 and 2 with prejudice. From exhibit 1 and 2, we see plaintiff number 2, 3 and defendant number 1, and for former defendants. For instance, other partners of partner number 57. Parcel account and plaintiff number 2 and 3 and defendant number 1 are the partners of partner number 72 of the parcel account. It is decided by the gossip in AI 1970 on Himachal Pradesh page 5 that delivery of possession is essential to complete the gift under into law. The defect of delivery of possession cannot be cured down by registration of the gift deed. It is decided by the law in AI 1975 Patna that the gift deed need not attested by 2 witnesses is invalid. Not attested by 2 witnesses is invalid. From the evidences and discussion above, we see that the land of DAC number 1017, which was gifted by defendant number 1 to defendant number 2, is in possession of the plaintiff, and defendant number 1 has not delivered the possession of the gifted land to defendant number 2, and gift was not attested by at least 2 witnesses. Attesting witnesses for which gift cannot be held. It is decided that the registered gift number 12 is illegal in the property and value. On this finding, my lord, suit was defeated. While this finding was reversed by the appellate court, my lord, by appellate judgment and decree, my lord. This is the finding of the appellate court, my lord. Page 11 may I appellate judgment, page 11, my lord.
Yes.
Page 11, my lord, start from para 30. May I read it? Para 30, my lord, let us see the provision later on in the transfer of property act, just to justify the submission of the land request for the section 123 of PP Act reads as follows. Next, my lord, I am speaking the provision, my lord. For the purpose of making gift of inventory property, the transfer may be effected either by registered instrument signed as aforesaid or by delivery of possession. Such delivery may be made in the same way as goods sold may be delivered. There is no dispute that the defendant number 1 has executed gift deed number in favor of defendant number 2 with regard to land which was inherited by him from his predecessor in interest, Korpana Devuchodin, and plaintiffs have challenged the same deed on the ground that state is invalid as the defendant number 1 had no position with regard to the same gifted land prior to its registration, and defendant number 2 cannot acquire title by virtue of state so-called gift deed. But it appears that gift deed number also was registered by the executed defendant number 1 as a step cannot be said to be void and illegal. The respondent plaintiff cannot challenge the validity and legality of the same instrument. Therefore, I find forth in the submission of the land counsel for the appellate with the above observation, I beg to disagree with the decision of the trial court. Trial judge, when he decided this issue in affirmative and against the appellant defendant. Accordingly, this issue is decided in favor of the appellant and against the responsibility. Issue number 6. This is an admitted question of fact that student covered by periodic pattern of 87 and 72 of Parcela Town, Badal Moja is an undivided land and co-partners having acquired near land jointly, but that does not mean that such a joint position is sufficient to deprive the right of other co-partners, and other co-partners have no right to transfer his undisputed title. Plaintiff Vijender Katur in report PW4 that his father, Horonath Devachodri, got 2 bigger 13 acres of land of Dangdama also, and 1 bigger 1 cut 18 acres land from Dangdama 1019, and 1 bigger 30 acres from Dangdama 265, 66, 33, 333, and 334. These witnesses can also deposed that land covered by Dangdama 1042 is mentioned in the DP, but the same is in possession of Horisha Chaudhary, and he is the owner of the said land. Similarly, PW5 Horisha Chaudhary, Devachodri reports that the plot of land measuring 2 bigger 3 cut 6 acres covered by Dangdama 107. He is in possession of the plaintiff since the 40 years, and he is in possession of the land measuring 1 bigger 1 cut 3 lesser in Dangdama 1042 of the Supra. After going through the evidences of the witnesses, it transpired that plaintiff had been possessing their respective plots of land by way of amicable settled in between the partners, and no formal partition was effected with regard to their respective shares in the suit partner. The evidence of the plaintiffs has clearly shown that they denied the right of the defendant number 1 with regard to suit partner on the ground that they have been possession their respective plot of land since 40 years, and defendant number 1 had no position of any part of the suit partner. But it is true that the defendant has no right title and interest with regard to the share of the suit since it is not partition. He has every right to transfer his part of undisputed title of the suit partner in favor of the defendant number 2 as per established principle laid down in section 54 of the TPA. Section 50 and 44 has been discussed, my lord.
Just a moment. Yes.
My lord, I'm reading paragraph 20 of this. Paragraph 21. There is a transferee of the share of dwelling house belonging to an undivided family is not a member of the family. Nothing in this section shall be deemed to be attaching to joint possession and other common or part of enjoyment of the house. It is an established principle. Madam, section 44 is a certain basta diya, madam, in respect of enjoyment, which is not applicable in respect of such suit matter, because all the parties hail from same petition. It is an established principle of law that co-owner, co-partner cannot challenge the right of other co-partner in connection with the share EP in the concerned partner. The learned counsel for the applicant has submitted that no partition can be effected in respect of the two partners between the partners here from the original partner component debauchery. It has already been discussed in issue number 5 that defendant number 1 had executed the gift deed in favor of defendant number 2 with regard to his undivided land in the suit partner, and the plaintiffs cannot challenge the validity of the said deed. And that does not mean that the defendant number 1 had no right or title over the land of suit partner prior to execution of the said gift deed. However, admitted position is that donor-donee cannot take possession of the exact position of their land without effective form of partition of their respective shares. In this regard, observation of the Honorable FS Court, Ramdas versus Sita Valena, reported in AI 2009-2375. As Koski mentioning, very Honorable FS Court held there, without there being any physical formal partition of an undivided landed property, the co-share cannot put a vendee in possession, although such co-share may have a right to transfer his undivided share. Honorable FS Court has also held in Conso reported as AI 1966 Supreme Court 470 that now it is well settled law that the purchaser of a co-person's undivided interest in the joint property is not entitled to possession of what he had purchased. His only right is to sue the partition of the property and ask for allotment of to him of which one partition might be found to fall in share of the co-personer whose share he had purchased. Well, this is the case, my lord, of the respondent before the trial court, my lord. And this is not the case of the my lord, appellate before the Supreme Court or before the trial court. I defendant number 1, respondent number 1 was not having his share in the suit against Patna. Share has been admitted, but transfer has been challenged. Taking advantage that this is not in his possession. So, my lord, from the facts, my lord, plain reading of the judgment and degree impugned this is appeal, my lord. This is my report submission, my lord, they do communicate and in this appeal judgment, my lord. My lord, in support of my concession, I am relying upon C judgments, my lord. First one, madam, 2000, AIA 2000 Supreme Court 46.
In these cases, in the first case, you have not marked the paragraph. Which are the paragraphs?
Madam, paragraph highlighted, madam. 15, madam.
Para
15, madam. Internal page number 7, madam.
15.
15, 1 5, madam.
Yes.
Internal page number 7, madam.
Yes.
Para 15, madam. We shall first deal with the proof that certified copy of the deed of mortgage.
So it's okay, just don't have time because
Madam. Madam, here in this case, my lord, this is the ratio leader, my lord. My lord, in respect of the deed of gift, my lord, if it is registered, duly registered and registration is approved, there are no necessity to court for the attesting witnesses. This is the ratio, my lord, of the judgment, my lord. Next one, my lord, AIF 2009, Supreme Court 2735, paragraph, my lord, 14, 16 and 19, my lord. Third one is, my lord, 1999, 1 GLJ 850, paragraph 10 is relevant, my lord.
yes. Yes.
Well, whatever is ground they have taken that the deed has not been for the, could not be proved, my lord, by calling for the attesting witness, those are not related enough, my lord. In the light of these judgments, my lord. In the submission, this is not changed.
Mr. Rekha, while you are closing the matter, you can, tomorrow morning, you can tell us, because since we find that the parties are related, if you can agree to a mediation, then we don't pass an order.
I'll take instructions.
Then what we'll do is that we'll fix the matter for further hearing and refer the matter for mediation. But you'll have to both contact the parties and tell us the dates on which they are willing to appear.
Very good.
Correct?
Yes.
And you'll always also tell us that you want to do the mediation here or at Borpeta. Correct?
Okay. Okay.
This-
Parsala, now Parsala court is there, this can be did Parsala.
Patshala, whether there is mediation center or not, we don't know. Whether there are 10 mediators, we don't know.
I can have information, madam.
We get information. But if it is not there, they are willing to come here also, but here there will be several sessions. They may find Borpeta to be more
Okay,
conducive.
both the parties.
We'll take the instruction.
Instruction.
So depending on what you say, the order is likely to change. Because tomorrow we may not have a single bench, I don't know.
We give
So-
court master morning.
We, if you are not agreeable to mediation, then we close the matter and reserve it for judgment.
My lord.
And just share the citations you have given to us.
Yes,
And the, if you are agreeable to the mediation, then we don't reserve it for orders.
Okay.
We'll fix the case for
Further hearing.
further hearing. And in the meantime, await the mediation.
Very good.
We'll give 1 month time for the mediation. It may be as many sessions as required. So within a month, they'll send us the report.
Very good.
So that is the tentative. Okay, my court master says that tomorrow there is likelihood of a single bench.
Apply to court, my lord.
I'm mentioning or will,
It will only be in the second half. The
Yes.
single bench will not be in the first half. My court master is informing that there may be a likelihood of bench. Order would be, tentative order would be, Mr. B.D. Decker, the counsel for the appellant is present, the submissions of Mr. A. Alam, N. Alam, then it's counsel for the respondent is concluded. Order is ordered. But there can be a second order also, subject to mediation. With mediation, then this order will not be.
obliged.
But in the morning, please tell the court master, because the orders are required to be uploaded. It can't be kept pending for so long. And other, what you call for mediation, all, it can be passed in the second half when you're there.